On behalf of my co-chairs, Professor Trish McMahon, Susan Chiodo, the three of us could not be more delighted with the session for today. I'm going to start by acknowledging our presence on the traditional territory of many Indigenous nations. We recognize that the area known as Tekaronto has been caretaken by the Haudenosaunee, the Anishinaabeg Nation, and the Huron-Wendat. It's now home to many First Nation, Inuit, and Métis communities. We further acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to share and care for the Great Lakes region. So my job is twofold today. One is in this introduction to just give you a bit of the lay of the land for what's happening over the next 3 days. And then I'm going to be introducing our first guest speaker who is here, the Honourable Michael Tulloch, Chief Justice of Ontario. I'll come back to Chief Justice Tulloch in a moment. Not a good idea to keep the Chief Justice waiting for too long. But before we get there, it's a great time to be talking about access to justice in Ontario and in Canada. It's always a great time. But our colleagues at the Department of Justice, I saw Catherine somewhere, and others were co-hosting with the OECD a big roundtable on access to justice a week or so ago. Next week, the Law Society of Ontario and other colleagues across the country, Access to Justice Week. So we are sandwiched in the middle to try and keep the love going and to talk about access to justice research at this forum. I'm also personally really delighted that Osgoode is hosting this event. We've got, I think, a long history of thinking about questions around access and justice through our long time exploration of access, clinical education. I saw my colleague Janet Mosher, who's been thinking about these things for years here, and other stuff. It's something that we care about a lot. And so I'm so excited and proud to have everyone come and spend some time with us here at Osgoode in this International Access to Justice Forum. Speaking of Osgoode, just to give you a quick lay of the land, some people, of course, will know this. Others from afar will not, because we have people, of course, online and in the room. We have people traveling from Australia and lots of other places around the world. Osgoode Hall Law School is part of York University. York has several campuses. Osgoode has 2. Our main JD program is housed up at the Keele campus, just north of here. If people want to go, the subway goes directly there. We are at our Osgoode Professional Development Campus here in downtown Toronto, and delighted to be having our colleagues here host us today. Given the weather and the space around, I do encourage you to explore the neighborhood. It's terrific, and we'll talk more about that later. So for today and the next couple of days, what's our thinking and how do we want to go ahead? By my count, there are 14 panels. Each panel has somewhere between 3 and 7 speakers, typically. We will sometimes have single panels in one room. We will often have parallel panels. We made the choice this year to celebrate the diversity of interest in this topic. We were overwhelmed with applications. We tried to include as many people as possible. And that's a risk, right? Because it makes for bigger panels, shorter time. But we thought the importance of the topic, the importance of the growing of this research around the world, that it's better to have more people in the game than less exclusive and having longer time to talk. So what I'm really saying is shut up, keep it short, and listen to your chair. But in all seriousness, shut up, keep it short, and listen to your chair, because it won't work otherwise. So it's not meant to be a joke. The idea is give your theme, give your quick hit of what the project you're working on, and then hopefully there will be lots of time for actually discussing questions, exchange, which I always find is perhaps maybe the most important part. We do have 3 keynotes. Our Chief Justice will be speaking momentarily. The Attorney General of this province will be, I think he's able to do it, but we expect him to be at the Law Society this evening. We'll mention that later on. And then on Friday, Justice Karakatsanis of the Supreme Court of Canada is going to be closing the panel at the closing lunch. So we'll get to Justice Karakatsanis later. I also want to spend just a second to acknowledge that these things don't happen in isolation. And of course, my colleagues at Osgoode is one thing, but this started long before we took it on. And I don't know where Lynn is, but we were talking this morning about the history of this project. And I got a call about a year ago from, I think it was Hugh and Nigel and maybe Lynn and Emily, who had just really been successfully doing this last year in Irvine, kind of saying, oh, it was a great conference. Canada hasn't done it. You know, Osgoode thinks about these things, kind of just totally sucking up to me and knowing that I couldn't say no because I'm such a suck too. So by the end of it, I was pleading with them if we could actually do it, even though their whole goal was just to push it on me. Anyway, this is the 3rd in a row. In 2022, it was virtual. 2023, it was at Irvine, and 2024, we're here. That was not the first time we've explored these issues together in this format, though. I know Nigel at the University College London and others, maybe Pasco and various folks, Hugh, were very much driving this for a while. Hazel and others. I know Matthew and Rebecca have been really driving the ship, and so many people in the room that I can't name everyone, but this is a village, and it's amazing to see so many friends from so many different communities and spaces here. So I'm excited. I'm going to get out of the way now for this role. I guess the last thing I'll say, and then I'm going to ask Erica if I've forgotten anything, is some administrative stuff. There are washrooms on several places on this floor, shared washrooms, individual washrooms, so you can find a place that's comfortable for you. Food service will be where you got the lunch. It's meant to be kind of buffet style. When you're done, feel free to put your dishes at the carts. You don't have to actually wash them, but you know, you can clean up. And then we will be coming and going, but it's meant to be comfortable. It's meant to be a community. It's meant to be conversational. Everything but the Law Society event will happen this evening. We'll give you directions for that. And we've purposely left some time for you to explore Toronto when we're not in this space. Finally, I want to thank Megan, Anita, and Erica, who's right in front of me, who really actually has done an incredible job bringing a huge range of people from around the world. These things are definitely not self-executing. So Erica in particular, thank you. So to the Chief Justice, the Honourable Michael Tulloch, Chief Justice of Ontario. I can give you the dates and the bio and all that stuff, but I want to make this short and maybe slightly more personal. Chief Justice Tulloch is a graduate of York University and of Osgoode Hall Law School. He was obviously a practicing lawyer here in areas of criminal law and what have you, was appointed to the trial court and then became the first Black appointee to the Court of Appeal for Ontario, and then the first Black Chief Justice for any province in Canada. It's a huge accomplishment that we're so proud of. And as part of his legacy, he's won medals and awards and been recognized by all sorts of people. One of the places that I thought was most touching, and I remember being at the ceremony, was Osgoode's, the Black Law Students Association gave their first Lincoln Alexander Award to Chief Justice Tulloch at the time. And I know that was very meaningful to our students and to the law school. Chief Justice Tulloch has also been really instrumental in how we think about education at Osgoode, and in particular, how we do admissions. And he was invited and helped and was the architect, I guess I can say that out loud, but certainly influential in how we redid our admissions policy to take a more holistic approach to the students that we admit, with the sole purpose of bringing in students to Osgoode who are as reflective of the communities who we are meant to be serving. And so we have Chief Justice Tulloch to thank for that important work that happened quite a while ago now. So with that, the last time I saw Chief Justice Tulloch at a formal ceremony, sort of like this, other than when we were celebrating our former dean, Peter Hogg here, is when I was able to be part of the ceremony where he received an honorary doctorate from York University. And that was a special moment as well. He's got other doctorates from other universities, but I'm not going to mention them. So with that, our plan is I'm going to invite the Chief Justice up now. I'll stay here. He doesn't need me to be beside him, but I will watch for any questions coming in from online. He will have some comments, and then I think, subject to time, we'll have a few minutes for questions, and then we'll get on to our next sessions. So with that, Chief Justice, welcome.
Great. Thank you so much. So good afternoon, everyone. Thank you, Dean Farrow, for that very warm and kind introduction. To Professor Patricia McMahon and your co-chairs, Professor Chiodo. Thank you for organizing this conference, and thanks. And thank you for inviting me to be a part of it and to give this opening keynote address. As Dean Farrow has indicated, I am a proud Osgoode Hall School alumnus. And I'm delighted that the law school is hosting the International Access to Justice Forum. I can tell you that Osgoode was a meaningful, I would probably say it was the most impactful experience that I've ever had in my life, those 3 years that I spent there. So, and it totally not only taught me how to think like a lawyer, but it opened up my eyes to what justice was all about. And I think when I went to Osgoode, this is back in the 80s, 86 to 89, it was perhaps the most innovative law school in Canada, with the most diverse group of professors. At that particular time, I first was introduced to what it really meant to, or start thinking about what access to justice actually means. And I think that was the first school, probably in the country, that experimented with clinical education and experiential learning through various types of clinics. And I think that was really the genesis of a lot of students of my generation really thinking about these issues. So I want to thank Osgoode for that experience that I've had, and but for Osgoode, but for my law degree there, I would not be here standing as Chief Justice. So hey, there's a direct link. I'm grateful. So it is an honor for me to be here today. I am grateful to the Winkler Institute for Dispute Resolution for generously sponsoring this address this afternoon. The Institute's namesake and one of my predecessors as Chief Justice of Ontario, the Honourable Warren Winkler, devoted himself to improving dispute resolution and access to justice. And he's now 80, I think he retired in 2014, right? So he would be 85 now. And he is still as busy now as he was when he was the Chief Justice. I understand that he is the key arbitrator, mediator on the tobacco case, and they just finished a portion of that. So, you know, Warren has been instrumental in the whole concept of access to justice in different forms. And so it's meaningful that the Institute is a part of this forum. When Dean Farrow asked or invited me to deliver today's opening keynote address, I immediately accepted. And while as Chief Justice of Ontario, it is not my place to comment or opine on public policy matters or matters that may appear before the courts, I recognized that this forum is an important opportunity to strengthen access to justice. I strongly believe that everyone gathered here today, members of the judiciary, lawyers, professors, government officials, and community members, has a role to play in achieving this goal of enhancing access to justice. I see my colleague, Justice David Brown here. I know I saw him walking in. It's good to see you, David. And I know that he'll be a part of this forum. So it's really meaningful. It's, in my view, the goal here of us all working together where possible and appropriate across institutional roles, disciplines, and geographical and political boundaries to make it happen is a significant message. And I understand that there are people here from England, from the US, from as far as Australia, in different parts of the world. And you know, it's important that wherever we are, we turn our minds to how we can actually make this a reality for the citizens and the people with whom we come in contact. I'm also grateful that the forum is bringing together a diverse group of scholars, practitioners, policymakers, and dispute resolution experts from across the province, the country, and the world to explore these new developments and ongoing challenges in strengthening access to justice. I'm pleased that you will be joined, like on Friday, by another dear friend of mine and a true access to justice leader, Supreme Court of Canada Justice Andromache Kasanis, who will deliver the closing keynote address. Now, I want to point out that the timing of this forum is impeccable, as next week, Ontario and other Canadian provinces will be making Access to Justice Week marking Access to Justice Week with a series of events reflecting on how we can further advance access to justice in this country. In Ontario, these events continue the innovative work of the Law Society's Action Group on Access to Justice. The Action Group launched Access to Justice Week in 2016 to bring members of the legal profession and other access to justice advocates together to advance awareness about access to justice challenges and build momentum to achieve solutions. Nearly a decade later, the week's events continue to bring together justice sector partners from across Ontario and Canada and the world to develop meaningful, people-centered solutions that advance systemic change in the justice system. So I would encourage everyone that is here who can participate in these events next week, please do so. Now, I want to begin by discussing what the importance of access to justice means. As you're all aware, there is a growing crisis surrounding access to justice in Canada and globally. This issue is not just a legal problem. It is a profound social crisis affecting the lives of millions of people and the integrity of justice systems themselves around the world. As I was preparing my remarks, my research took me to the recently published book of my good friend, Dean Farrow and Professor Leslie Jacobs, entitled The Justice Crisis: The Cost and Value of Access in Law. Now, this book offers a critical and timely exploration of the escalating challenges surrounding access to justice. Their work draws attention to the true cost, both financial and societal, of the barriers many Canadians face when trying to access the legal system. The book makes clear that without meaningful access to justice, the rule of law itself is at risk. So as my good friend Dean Farrow and Professor Jacobs note, access to justice is not a luxury. It is a foundational right that underpins the very structure of our democracy. It ensures that every Canadian, regardless of economic status, social standing, or geographic location, can exercise their legal rights and receive fair treatment under the law. I also agree. I agree with my colleagues' observations that access to justice is about more than just getting to court. It is about ensuring that legal solutions are available, affordable, and comprehensible to everyone. It is about providing the means to resolve disputes fairly, without undue delay, and in a way that maintains public confidence in the rule of law. This is critical to people's lives because we live in what scholars have termed a law-thick world, where law impacts everyone's daily lives and their ability to meet their needs. Yet, as Dean Farrow and Professor Jacobs argue, this ideal is far from reality for many Canadians today. The barriers to justice are numerous and multifaceted. For some, it is the prohibitive cost of legal representation. For others, it is the complexity of the legal system or the geographical distance from legal resources, particularly in rural and remote areas. And I'll just give you an example. A few years ago, I was tasked with reviewing two institutions that govern our policing in Ontario. Police, I conducted a review on police oversight and another on the conduct of street checks or carding. And during the process of those reviews, I decided to travel throughout the province of Ontario. And it took me as far north as Pekanjicum into the First Nations reserve north of us. And what struck me was how difficult it was for us to access that particular reserve. And it was not unique to that reserve. There are many flying communities like that, and accessing justice meant that judges had to be flown in, prosecutors, defense lawyers, and the facilities where these hearings would have been held were in council chambers, but nothing like what we can imagine here. So it struck me then how challenging this particular and real this particular issue is for many of, not only citizens, but individuals who should have the right to the same level of access to justice as all of us. So the barriers to justice are numerous and multifaceted. For many, it is simply a lack of awareness of their legal rights and how to navigate the system. These obstacles create what the authors call justice gaps, disparities between the promise of justice and the lived reality of those seeking it. And I remember when I was a student here at the law school, I saw this firsthand when I would participate in the legal clinics, and how dealing with indigent clients, a lot of them were in their situations because they just did not know what the law was or what their legal obligations were. And so there was a gap in their knowledge. And it affected their abilities to not only comply with the law, but also to access the appropriate legal advice and thus access justice. This brings me to my next area of focus, which is how the justice system is doing here in Ontario to meet the access to justice needs of the people it serves and its successes and challenges. Now, as chief of this province, I firmly believe that the people of Ontario, by and large, are well served by our justice system. But at the same time, there's much room for improvement. We're blessed with a strong, fearless, and self-governing bar, scores of outstanding law schools. Osgoode is one of them. I won't talk about U of T, by the way. No disrespect. I have 3 of my staff here, from my clerk, Justice Brown's clerk. As a matter of fact, Justice Brown is a U of T graduate. But anyway, I won't talk about U of T. We're here to talk about Osgoode. But anyway, so, and Misha, I hire a lot of U of T students. But anyway, I know. The point is, right? Like, I mean, we're blessed, right, with some amazing law schools. In fact, you know, we have, I think there's now 16 or 17 law schools in Ontario, right? Some years ago, there was 15 without TMU and without, is it Lakehead?
Yeah, and growing with all of them across the country. They're just growing,
right,
numbers of them.
But the good thing is, and I did this review back in 2006 of the admissions, and I had the chance to do a deep dive into the quality of legal education here in Canada. And we're amazed, we're blessed with the highest of qualities. It's, you know, no disrespect to the US, but there's different tiers of legal education. So if you're gonna go to a law school in the States, you gotta be very careful. So I would say that our schools are all considered Ivy League schools here. So anyway, I can say that because I'm not a professor, so I'm not like doing a commercial for any of the schools. But I'm the Chief Justice, and I can say that, right? I don't have a difficulty hiring any law students from any of the law schools here because they're amazing schools. So it's a robust legal academy, respected and independent courts, and governments that by and large are committed to supporting the justice system. Now, I know that the Attorney General will be speaking later. I hope he does speak, because we need them to fund more resources in the system. And in fact, the message should go to the Premier to say that the administration of justice should be a key consideration for the cabinet. I remember when one of my predecessors was the Attorney General, that's Roy McMurtry. He was one of the key ministers in the government, and whatever was needed in the administration of justice, we got it for this province. Since I think it was Ian Scott, the role has not been respected in the same way, and we need it to be, because we need justice to be a priority for our provincial governments and for all governments. And I would say the exact same thing to the Canadian government when it comes to, you know, the Minister of Justice. Over the last year, we've seen some real serious issues surrounding the appointment of judges and the various gaps in the vacancies and how long it took. And that impacts justice. It impacts justice because there are delays in the court systems that are not being addressed, or that should have been addressed and should have been dealt with, but could not be because of the lack of resources. And so that's also within the realm of the government to ensure that our justice system are fully funded, that our legal aid system is adequately and fully funded, so that individuals that have legal issues before the court feel that they have a voice, and everyone should have that voice. There should not be a disadvantage within our system because of lack of access to legal services. As well, our system benefits from sturdy guarantees of rights, protection in our Constitution, statutes, and common law. Notwithstanding our challenges, there are much to be proud of. In 2003, the World Justice Project, an international civil society organization, which evaluates countries' adherence to the rule of law each year, ranked Canada as one of the countries with a strong commitment to the rule of law. It reports that Canada is a top performer in fields that are critical to public confidence in the justice system, such as freedom from corruption and improper government influence, protecting fundamental rights, maintaining order and security, and enforcing government regulations fairly and effectively. The project's reports show that Canada has maintained this commitment, even though in many countries, the rule of law is declining. At the same time, we must recognize that people in Canada do face barriers to access and justice that have long been and remain a serious concern. As the World Justice Report shows, while Canada's justice system is generally the envy of the world, Canada performs less strongly than some of its peers for delivering timely, affordable, and accessible justice. Far too many Canadians cannot access justice for financial reasons. For many, particularly the middle class, they can neither access legal aid nor afford to hire a lawyer. The result is a challenging set of choices: to use up family resources in litigation, to represent themselves in complex legal matters, or to abandon justice altogether. And even those who can access justice sometimes face undue delay. Now, the Supreme Court of Canada's 2016 Jordan decision shone a spotlight on the challenge of delay in criminal cases. But it is also a serious challenge in civil cases where, unlike in criminal cases, there are no constitutionally guaranteed resolution timelines. When justice is inaccessible, the consequences are severe and far-reaching. Financially, the cost can be crippling. Many Canadians simply cannot afford legal representation, particularly for civil matters such as family law, housing disputes, or employment issues. As a result, individuals are increasingly forced to represent themselves, often with little understanding of the law or court procedures. This not only places immense stress on individuals, but also on the judicial system itself, as cases involving self-represented litigants tend to take longer and require more judicial resources. But the costs are not just financial. The emotional toll of navigating a complex and intimidating legal system can be devastating, particularly for vulnerable populations. For those facing family breakdown, eviction, or job loss, the inability to access legal support can compound feelings of helplessness and despair. The longer-term societal costs are also significant because unresolved legal problems can lead to poverty, homelessness, and mental health issues, creating further strain on social services and communities. Perhaps most alarming, as was highlighted by Dean Farrow in his text, is the erosion of public confidence in the justice system itself. When people feel that justice is out of reach, they lose faith in the system designed to protect their rights. This lack of trust can lead to cynicism, disengagement, and in some cases, a turn to extra legal means to resolve disputes. I saw this firsthand when I was reviewing the civilian oversights of policing. In Canada, we pride ourselves in being a society governed by the rule of law. But the rule of law cannot function if the law is inaccessible, or if it's inaccessible to a large segment of the population. The justice systems, as we know it, is not just for the wealthy or the legally sophisticated. It must work for everyone, or it fails in its most basic function. So, to further our work, we must consider how to improve access to justice. It entails the following: strengthening collaboration, embracing learning and knowledge sharing, integrating technology, and empowering people through civic education. I will begin with this concept of strengthening collaboration. Meaningful access to justice in Ontario is a collective responsibility, requiring collaboration among a broad spectrum of stakeholders, governments, and attorney generals, as I've stated earlier, alongside the architects of our civil rules, criminal procedure rules, and family rules, must work in unison to create a legal framework that is not only efficient, but accessible to all citizens. The rules of court must account for the diverse realities of those who interact with the system, ensuring that legal processes are streamlined and adaptable to meet the needs of every individual, regardless of their background or the nature of their case. Now, specialized courts such as mental health courts or restorative justice programs further demonstrate collaborative effort, recognizing that a one-size-fits-all approach to justice fails to serve vulnerable individuals or address the root causes of criminal behavior. Equally important are our law schools, which must be attuned to the evolving legal needs of their communities and broader society. Future lawyers must be equipped with the tools to serve marginalized populations, as well as to engage with restorative justice measures that promote healing and long-term solutions. Social agencies such as legal aid and the provision of language translation services are crucial in bridging gaps for those who might otherwise be unable to access justice. And finally, we must ensure that the needs of victims of crime are met with empathy and support, while also recognizing the unique challenges faced by marginalized individuals and communities. When all these components work together, access to justice becomes more than a goal. It becomes a lived reality for all Ontarians. Secondly, I want to elaborate on the concept of embracing learning and knowledge sharing. In addition to improving collaboration, we must also embrace continuous learning and knowledge sharing. We must begin these efforts by learning from people the justice system serves. As a people-centered approach to justice teaches us, the perspectives of the people who use the system should be central to any program or reform. That is why it is important to dialogue with people with respect to their needs and learn from them about how the system succeeds and struggles to meet those needs. In addition to dialogue, we need to collect better data to understand people's justice needs and experiences. Such data will help prevent us from designing access to justice strategies that are based on anecdotes or misperceptions of people's needs. We also need to learn from other institutions and disciplines. Let's face it, while lawyers learn how to think like lawyers in law school, it is rare, at least in my day, that we also learn the principles of sound public administration or how to design processes that deliver quality services to the public. So we have much to learn from other disciplines, such as public administration and behavioral sciences, business, technology, and organizational theory, about how to design legal processes that can reliably meet people's needs. It's interesting. I was thinking about this because, I've been the Chief Justice now for just under 2 years. December will be 2 years. And I thought about what is the most impactful course that I ever took in university that actually helped me for this job. And I go back to my undergraduate days of business and economics. I took a course called organizational behavior. And that is a course that is the most important course that I'm now drawing on in this job. So it shows that, that's not a joke, by the way, because I got to deal with people's personalities and all that. But it's about organizing a system that works for everyone, right? And being able to think outside of a very narrow box. And so as great as law school was, I took tax, business, organizations, and all the other business courses that were very important. They helped me when I was practicing law, but certainly not to rethink and reimagine a more impactful and effective system. So we have to work collaboratively. I spoke earlier about my colleague, Justice David Brown, who's here, and he'll be addressing these topics in greater detail during the panel that Professor Suzanne Chiodo is chairing this Friday concerning court and tribunal design. So I encourage all of you to attend and participate in that discussion. We need to learn from each other across jurisdictional boundaries, across disciplinary boundaries. It is particularly exciting that this forum emphasizes international cooperation and cross-border dialogue, because improving access to justice is a global project. Every member of the United Nations shares Sustainable Development Goals, Goal 16's commitment to providing access to justice for all. Indeed, scholars and policymakers alike have described access to justice as the key driver of peace, security, and equality for everyone in the world. Cross-border dialogue allows us to draw on a wealth of experience and expertise to solve challenges like the high cost of legal services and the challenge of delay that other jurisdictions share. By engaging with colleagues from around the world, we can learn from their successes, adopt best practices, and innovate in ways that improve our justice system. As we learn from other countries, we have a responsibility to share our knowledge with them as well. For example, just a couple of weeks ago, I met with a large delegation of judges, prosecutors, and community advocates visiting from Kenya and the NGO Equality Effect and their 160 Girls Project. The delegation was visiting Toronto to learn from judges, lawyers, and academics here in Canada how to better prosecute and judge sexual assault cases and protect women and girls from sexual violence. By sharing our knowledge and strengthening these international relationships, we can strengthen the goal of achieving the global rule of law and ensure that access to justice remains a priority on the international agenda. That is why I would like to also take this opportunity to celebrate Canada's International Judicial Assistance Program. This program, known as the Technical Assistance Partnership, is spearheaded by the Office of the Commissioner for Federal Judicial Affairs Canada and robustly supported by Global Affairs Canada. It helps countries deliver access to justice, protect the rule of law, and judicial independence. It also helps to empower women and girls and promote gender equality. And it does so by employing a collaborative, people-centered, and multidisciplinary approach by bringing together Canadian judges, lawyers, private sector experts, and government representatives, and engaging the Canadian and international audiences. This is something that's dear to my heart. I've been a part of this advisory committee to the Federal Judicial Commissioner for the last 15 years. And I'm currently the chair of the advisory committee on international engagement. And I'm proud of the impressive results that the program has and is continuing to achieve. So as we speak, in the Ukraine, the program is supporting that country's legal system to reunite children displaced by the war with Russia, with their families, and ensure that the state can care for them. In Colombia, we're currently assisting by helping to establish specialized pilot courts for domestic violence that are improving women's ability to access justice. And in Ecuador, the program is helping that country implement its constitutional commitment to adopt an indigenous justice system. The program reinforces Canada's role as a global leader in judicial reform and development, which are essential to ensuring access to justice for all. Now, this brings me to my third point, which concerns integrating technology. The importance of integrating technology into the justice system is crucially important. In an increasingly digital age, a people-centered approach requires us to help people access the justice system using the digital technology that they use to do just about everything. The rapid digital transformation of the justice system during the pandemic demonstrated that technology offers powerful solutions. We know from the Everyday Legal Problems report that I mentioned earlier that before the pandemic, travel for court appearances and expenses for things like preparing hard copy materials were significantly increasing the cost people face to access justice. When the pandemic began, courts in Ontario and across North America quickly transitioned almost overnight to virtual appearances and e-filing. We now know that these shifts, though not without challenges, have brought real benefits. The work of Justice Sam Thurma from the Court of Appeals of the great state of Arizona, who is with us here today, although I don't know you, Justice, I think your work is important. It's an excellent example of what technology is doing. And as I've read about the work that you do, I understand that you will be explaining in greater detail during this afternoon's Justice Digitization panel how remote appearances are significantly improving court appearance rates and reducing costs to litigants in Arizona. That is why we're embracing digital transformation here at the Court of Appeal for Ontario. In the coming year, the court will launch an e-portal, an online filing and payment system for the court. This new e-portal will enhance access to justice by making it easier for people to communicate with the court. It will also cement the court's shift away from paper filing, a practice that unfortunately drove up costs for litigants. In addition, the Court of Appeal and the other courtrooms across the province are installing new video equipment to better accommodate remote and hybrid hearings. This will help reduce cost and improve access to justice, especially for routine matters and people in remote communities. We all have more work to do to integrate technology, especially artificial intelligence. My colleague, Justice Peter Lowers, who chairs the Artificial Intelligence Subcommittee of the Ontario's Civil Rules Committee, recently stated that we cannot take a head in the sand approach to AI and other developing technologies. And I agree. British Canadian Professor Geoffrey Hinton, who recently received the Nobel Prize for Physics, who has been widely credited as a godfather of AI, has called on everyone to both embrace AI because of the many benefits that it entails, but also he cautions us to develop appropriate ethical standards and regulations so that it doesn't rule us, but we rule it. I'm glad that the forum will be addressing these topics in its AI and legal tech panel tomorrow. A key part of the solution lies in embracing innovation. Technology offers tremendous potential to bridge the access gap, whether through online dispute resolution, legal information portals, or apps that help individuals navigate the legal system. However, technology alone is not enough. We must also focus on simplifying legal processes, expanding legal aid, and promoting early intervention services that prevent small legal problems from spiraling into larger, more intractable ones. And finally, we need to delve deeply into the concept of civic education. We have to empower people through civic education. So when I was a kid, right, civics was a part of my curriculum. I don't think it's the same now as it was then. I mean, we have OGEN, and I will be speaking about that it's a great resource that almost take the place of the school curriculum. But we need to integrate within the school curriculum a robust civic education. We're in a time of polarization, politically and otherwise. And with the advent and the increase of social media, where everyone is their own source of the news, it becomes extremely dangerous when we're uneducated in our responsibilities and the underlying principles that govern our society, that make our society what it is. And that's what I learned when I was a young child studying civics in school. We don't have that anymore. So we need to promote civic education because it leads to better citizens. It builds bridges. It enables people to find common ground on the democratic front and understand and appreciate the rule of law principles that unite us as a society. It helps people understand how the justice system operates and helps the justice system understand how it can meet people's needs for the better. We're in a society where people don't respect institutions anymore. Why? Because they don't understand its value or its importance to how we got to where we got to. So you want to tear it down because you don't really understand the fundamental principles as to how you got here. And that's the danger when we're ignorant of our history and ignorant of the institutions that civics would teach us about. These initiatives need to take root not only here, but globally. They help people, especially people from marginalized communities, learn what resources the justice system offers to address the marginalization and legal problems they face. Both civic education and legal empowerment are critical because without them, people may not realize that the justice system can offer solutions to their problems. And if we can't offer solutions to their problems, we're going to be relevant, right? We won't have the confidence of the people that we're serving. So there will be, as you say in your book, a crisis of confidence. And I think we're seeing that now. Surveys from the World Justice Projects and Legal Needs in more than 100 countries show that fewer than 1 in 3 people understood that the law offers remedies for whatever justice problems they were facing. So I am heartened that courts and community leaders are working together across Canada to foster civic education and legal empowerment. And here in Ontario, the Ontario Justice Education Network helps young people build their legal capabilities and capacities by strengthening their ability to manage the legal aspects of their everyday life. But I don't think OGEN is sufficiently enough, right? So I read this morning that the premier was, and I'm not opining about politics or their policies, right? But they're thinking about reviewing the education system, right? And I think we would all be served way better if in that review they incorporate with a mandatory part of the curriculum, civic education. OGEN, it enables dialogue between young people in the courts through initiatives like the OGEN Charter Challenge that the Court of Appeal hosts each year. These initiatives help young people from all communities to consider careers in the justice system. And just earlier this month, I learned of the Justice Day camps that the Nova Scotia courts hold in collaboration with the provincial government, lawyers, schools, and community groups. So all of these are important initiatives that will make us as a society better. So in conclusion, I want to emphasize that the conversations you're having here at this forum are not just theoretical. Instead, they're the seeds of real and meaningful change that will require constant reflection, adaptation, and action to grow into something worthwhile. Access to justice is embodied in the lives of the individual people, families, and communities who are seeking justice. By working together across sectors, borders, and disciplines, we can create legal systems that serves everyone. So again, I want to thank you for the opportunity to speak with you today. Thank you to each of you for the work that you do every day to advance the cause of justice. And as we leave this forum, let us be inspired by the stories of resilience and innovation shared by all our colleagues from around the province, the country, and the world. And let us carry forward the spirit of collaboration and continue to break down barriers until justice is served within all of us. So thank you.
Thank you, Chief Justice. I'm going to open the floor up. We don't have a wide open space of time, but we've certainly got time for some questions. And I just want to remark, I was hoping when we invited the Chief Justice to give some comments to inspire the next couple of days. And what I think what you've really done is given us not only inspiration, but some marching orders to really explore a bunch of stuff, which is terrific. So thank you. Thoughts, questions? I know it's such a shy group. We do have a microphone in the middle, or I can hand it around, but, and maybe what I'll ask is, there may be lots, so quick questions, quick answers, and we'll try and stay with the theme.
Thank you, Chief Justice. That was brilliant. My name is Dr. Liz Curran from Nottingham Trent University in the UK. I had the privilege yesterday of meeting some wonderful people at the Association of Law Clinics Ontario, who were very generous and open with me. And in the course of the conversation, something came up, and I'm interested in your reflections on whether you think this could be a useful piece of work to progress things for access to justice. So one of the things that Lenny was talking about, and you emulate this actually, is the incredible role of clinical legal education in promoting people who might go to large firms or become judges or end up in the commercial world, but building this collaboration or allyship, even though they're in different roles in government, in large law firms or whatever, they are really important, or the bar, whatever, they are really important in terms of continuing the collaboration around a commitment and conviction to improving access to justice when it's under siege, as it is, as you said, in so many countries. Mm-hmm. So one of the things I was wondering if you had any reflections on the power, if you like, of clinical legal education in buying people unusual suspects as allies in the fight for access to justice, given your own experience of clinical programs, and whether or not you thought there might be some clinical legal education research value in exploring the role of alumni in and their commitment and conviction through their training in clinical legal education, where they had access to disadvantaged people experiencing disadvantaged.
Okay, so the answer is, I think it's critically important. I can tell you that my own experiences when I was a student at Osgoode, and thanks to Mary Jane Mossman, who at that time was my associate dean, I was introduced to the Jane Finch Legal Aid Clinic that was working very closely with the law students at that particular time, and also Parkdale, right? And I think Parkdale was perhaps one of the first clinical legal education clinics that were established in any of the law schools here. And what I remained, just context, right? I remained on the board of the Jane Finch Legal Clinic for about 10 years after I graduated law school. I became, I not only clerked, or I had articled in a corporate civil firm. I'd also gone to the Crown's office as a Crown prosecutor. And while as a Crown, I was still on the board of the clinic. What it taught me from my days as a student was how important access to justice was in a real sense, by experiencing it myself, by dealing directly with individuals that were disadvantaged and could not, for all sorts of different reasons, access it. for the students who did not go into, we called it poverty law back then. A lot of them, they went on to corporate firms, but they were able to establish pro bono law within those firms. They were able to, to dialogue with their associates and partners in the firms as to the value and the importance for the society and for the communities in which they live, for them to devote time and sometimes resources to clinics and legal educate and overall legal access. So access to justice. So I think it's a win-win situation for all the law schools and law students to be introduced and to be exposed to these aspects. I subsequently became a judge. I was a judge for 9 years on the Superior Court in Ontario, and I saw firsthand how important access to justice was. Myself and Justice Paul Perel, we put together the first template for self-represented litigants when I was a part of the education committee on the Superior Court. And a lot of that came from our experiences as students being exposed to these clinics. As a judge now, as a judge on the Court of Appeal, a big part of our program is the inmate appeals, right? That was really, and it's been a part of our court system for a very long time. But one of my former colleagues, Justice Mark Rosenberg, he kind of took it to another level to ensure that everyone on our court participated and understood its value and its importance for, sometimes individuals that you may feel don't have any, like, not a strong meritorious appeal. They still, and they may be in jail for a long time, but they still have their day in court, right? And it's important for our system of justice to be, widespread, accepted by all. And it means those that are disadvantaged and marginalized, and those, who feel that the system may not have represented them. And so I think it's important. And just so that you know, on our court, judges are participating in this that are coming straight from corporate firms who've never been in a courtroom, but they would have been probably in a law school that exposed them to some of these clinical programs.
Liz, sounds like a great project that you've got there. So we've got time, I think, for one more question, actually, just given the time. Kate, why don't I bring you the microphone? And as I walk, Liz, you can talk to Lenny, who you quoted, who's in the back row. So
thank you very much, Trevor. Kate Gower from the University of Victoria and the Justice Data and Design Lab. Thank you very much for your talk. I really believe Ontario courts were a great leader in innovation during case lines. One of the things that occurred was a shift to a paperless hearing process and the use of the program Case Lines, now called Case Center. And I'm very curious to know if we'll be seeing any reports on the qualitative and quantitative impacts of that shift to using that paperless environment for the hearings. And also, I'd be very curious to learn about how the court handled that change into a new environment for everyone involved. Mm-hmm. So a lot of curiosity coming from me, and I hope a few others, about that experience.
Okay, so the first question is whether or not there's going to be some kind of evaluation of its progress, and it's whether or not it's successful. And I think that's an excellent question, and I will ensure that we do have that as we move forward. I can tell you that for me, technology was very important. So I have a young lawyer here with me who is my research lawyer now, and he was one of my law clerks 5 years ago, Misha. And that was, Misha clerked with me before the pandemic, right? And all my clerks for the last, I'd say, I've been on the Court of Appeal now for 13 years. And almost immediately, I would have all my clerks, it was a pretty tedious task for them, but they would photocopy the they would photocopy the factums and some of the main materials, and then put it on. I had a I created my own Dropbox, and we'd put it on there, and so we would communicate and utilize. Like I have everything on this, right? And I saw how seamless I was able to work. And I think as time progressed and more of my colleagues found out about this, they thought it was a good idea, right? Now, having said that, there were some colleagues that have never used a computer, right? And it's a generational thing. And for them, it was more of a challenge. But I think we're now at a stage where pretty much most of the court is computer literate. And I think they see the value, both from the ease of, like, you can work wherever, you know, like the days when I first started, and I've been a judge now for 22 years, we used to have these boxes of documents that we would track around with us wherever we were going. So on the weekends, every single day, we would have boxes and boxes of materials that you're reading. Now all of that is here. So I think it's a no-brainer from that perspective. And you know, the case line issue of filing, I think it's the same for younger lawyers. I think most of the lawyers now, they matriculated through a technologically literate world, right, in law school. So it should be a lot easier, and I think it makes it much more efficient. And in turn more accessible, right? So I think it enhances access to justice.
Great, Chief Justice. First of all, Kate, thanks for the question. I know there are other hands up, but I think that's going to be part of the nature of this week. There's going to be stuff that people just don't get to, or have the conversations in the hall and what have you. But in order to stick with our time, I do want to end this session. I've got a couple notes before you go, so don't go anywhere. But for now, I just want to say, Chief Justice, thank you.
Thank you.